topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show, where we bring you the finest experts in the field of legal, health, financial, and home improvement. This is the first Thursday of the month. That means K. Bender Rimbaum. Now, I got to tell you, this show and two other shows have been with us for basically the last 12 years. Our company has compiled over 4,300 emails and texts. We decided to do a survey on our most popular show, and we sent out an email blast to 4,300 people who we know have written us in the past. The number one rated show of all, and we do 35 shows a month, of all of our shows is K. Bender Rimbaum. The Thursday show, the South Florida show. Now, they do a show in Orlando, and that was in our top 10. And so was our Tampa. They were in our top 10. But this show is rated our number one show. Good afternoon, Robert.
Hey, good afternoon. Hello, everybody.
I thought that was so cool. We got all, first of all, I was surprised how many people responded to do a survey, but you've got the number one show of all of our shows.
Well,
I thought that was incredible.
That. There's a lot of interest in this topic, that's for sure.
No, you know what though, Rob? Okay, yeah, there's a lot of interest in this topic, but I got to tell you, the way you explain things, people really appreciate that. And I don't know how many of your clients share with you, but we have a lot of board members that just set the 5 o'clock hour, first Thursday of the month, set it aside and listen. And they don't just listen to 5 or 10 minutes. They listen to the entire show. One other thing I want to tell you is people really appreciate the effort that you give because, you've got a busy law practice and people really appreciate the time you give, and they share that with us also.
Well, it's always been actually fun for us to do this. So it works both ways. We're having fun and they're getting good information. So,
well, I got to tell you, your show is so easy to do because we get so many letters, people with their questions, and we actually have to decide which ones because the show is only 50 minutes, but we have got a ton of shows and everybody wanted to know about the new laws, and we've actually decided that there's better ways to educate, especially board members. And so if you've got a question, we're going to kind of stay away from that topic. We might have some questions that might come close to that, but I want to ask you, with all the laws, and it seems like it's mostly condo, Robert, more than
this year,
HOA.
yeah. This year was kind of focused.
Did you have a favorite? Were you overall happy with the new laws or still dissatisfied?
I don't think happy is the way to describe with new legislation. We try and hope that the negative aspects of it are minimized, but there are, as there tends to be, a number of things that were overdone and over legislated, and in a way that tends to create more problems than it's trying to fix. And we understand the intentions are good, but it seems like the people that are putting these things together would benefit from more input from people like myself in the industry that aren't necessarily looking to benefit one group or another, but to get the legislation in a form that accomplishes the goal without creating more problems. One example, there's a concept that's been in the statute for 50 years. If the board adopts a budget in a condominium that's more than 15% than the year before, the owners would have an option to create a substitute budget and upon a vote of the owners, pass that instead. It's something that I've never seen actually successfully done, but it's an option that existed. So what they did this year is eliminate that and require the board to create two budgets, one that incorporates their needs, and then a second one that takes away, quote, discretionary items, but that's not defined. And so what's discretionary? You adopt a budget to cover what you need to spend. So where's the benefit? So now the owners no longer have an option to create an alternate budget. That's gone. I don't know what the logic was on that, but that was one of the things that stands out to me when I look at these things. A lot of things that they do in there don't do a whole lot, but there are things that tend to create more problems than they fix.
Well, one of the things also that we get from letters is it's so amazing. Your show's been running, I think, 12 years now. It's so amazing that people are still first finding the show. Tell people about K. Bender Rimbaum.
Okay, Bender Rembam is a law firm that specializes in the field of community association law, condominiums, homeowner association, cooperatives primarily. We represent associations in this aspect of it. Been doing so continuously since 1992. I myself have been focusing in this area since 1987. We have 4 offices. Our main office is in Pompano Beach. We have an office in Palm Beach Gardens, an office in the Orlando area in Winter Springs, and one in Tampa. But we pretty much can cover the whole state, given the ability to do stuff remotely, as so many people do now. We have a large portion of our general association attorneys are board certified by the Florida Bar in the area, which is a higher level of specialization recognized by the bar that requires a certain level of experience, a certain level of continuing education, as well as the passing of a test that is geared to be not an easy test and covers a lot of areas. So of the 20 attorneys, they don't all do a community association general representation, but we have 10 or so that are board certified in that, and one that's board certified in construction defect matters. So we have extensive expertise in the area. We have built our reputation based on providing high quality legal services in a cost effective manner. Relatively, I mean, legal services are never entirely inexpensive, but and we present in a way that's understandable to our clients. We've had many clients come to us. They've had prior legal counsel that takes weeks to answer relatively simple questions, and then provides them with things that they read and they don't understand what they're reading because the technical terminology is very extensive. So we present in a way that would be most understandable by the layperson, because our clients are not experts in the field. They're volunteers working for the betterment of their community, and we recognize that.
Well, what we do here is we go by your letters, and you can text them to 954-336-3767. We have got a ton of questions today, so we're going to go get to those questions. We're going to start off with Don in Miami. He wants to know if a current of directors member hits the 8-year term and a year and a half into a 2-year term, is he or she automatically off the board, or does he or she get to finish the term before being termed out?
Well, this is a condominium question, and we want to remind our listeners when they send these things to identify if you're talking about condominiums or HOAs or cooperatives. In 2018, and who would have thought we'd reach this point, the legislation was adopted to limit the ability of a board member to serve more than 8 consecutive years, and there are exceptions that are allowed if that were to happen. So it always seemed like it was so far in the distance. So that doesn't kick in until July of 2026. When that does kick in, if you have someone who's been on the board for 8 consecutive years and they're in the middle of a term, they're not off the board. It just limits the ability for them to run at the next election. And if there aren't enough candidates to fill the board, then they'd be able to continue to run. Or if a supermajority of the unit owners vote in favor of them, I believe it's 2/3, then they can run again, or serve again. So they wouldn't be automatically off the board. They'd be allowed to finish out their term. But again, that's something that doesn't kick in until next year, assuming the legislature doesn't decide to change that in their next session, which is always a possibility.
Beth in Delray Beach, what can a member do? Oh, this is an HOA, Robert. What can a member do to enforce a violation? The ARC states it will not be enforcing certain violations like running a business out of your home or not following a color look.
Well, it's an interesting suggestion. The ARC is supposed to be Architectural Review Committee that deals with exterior appearances of homes. So the issue of running a business would not fall within their purview. Typically, that's for the board to enforce. If the governing body, be it the board or some committee that the board appoints to handle enforcement, is not uniformly or fully enforcing restrictions within the community, they would be subject to claims of being in breach of their fiduciary duty to the community, which is to fully and uniformly enforce the restrictions of the covenants, and that it could be a lawsuit that owners can bring against the association. The preferred method of resolving issues of that nature is more through the election and or recall process and changing who's on the board. It's a lot less expensive and time consuming to change the people who are on the board than it is to file a lawsuit to compel the association to enforce documents that they haven't been enforcing. When an association doesn't enforce restrictions within the covenants, for a period of time in excess of 1 year, it creates a defense to all owners of cuts waiver and as well as selective enforcement for any future enforcement, and the association would be precluded from bringing any enforcement on that particular topic until such time as the board republishes the restriction through a notice sent to the entire community identifying the specific restriction that hadn't been enforced and identifying a date when it would be, with the requirement to grandfather in existing violations. So it's a going forward enforcement. And so then they'd have to figure out a way to keep track of the existing violations. It can be complicated. It makes the operation of an association smoother and better if the board or committees in charge of such things uniformly and fully enforce all of the restrictions. I mean, that's their function.
Can a board vote on a communications policy enforceable by fines to stop owner from writing emails directly to vendors or directly to board members?
Well, emails to board members is a little more problematic because I think owners have a right to communicate with board members, and board members might not want to be on a board if they feel they need to insulate themselves from receiving communication from their membership. Communicating with outside vendors is a bigger problem and should never happen. Unit owners are not entitled by virtue of being an owner to communicate with vendors. All that has to go through the proper channels of the association. Fines can be set up for that. I don't necessarily believe fining is the best remedy to resolve that. Unfortunately, the only other method would be through court action and obtaining an injunction to compel the person to stop interfering with the operation of the association. It would be the intent to pursue the legal fees and costs that are expended in having to take such action. But in each case, we want to review the documents and see what our opportunities are in dealing with the enforcement. I wouldn't say there's a blanket policy that's better than any other.
We're going to get this last question in before we go to break. Jerry in Pompano wants to know, is it okay for a condo board president to walk through the community answering residents' questions about HOA business?
Well, legally, it's okay. There's no law that precludes a board member or president from discussing association business with the membership, with the caveat that if there's something sensitive, if there's pending litigation, if there's thoughts of litigation or negotiations involved with third parties, either in contracts or construction defect issues or whatever it might be, and certainly the assessment accounts of owners should not be discussed in such a form. But in general terms, there's not a legal problem in doing so as long as they stay away from what would be sensitive issues.
We're going to go to a short break. When we come back, we're going to talk. God, you got a lot of classes coming up. We're going to talk
Not so many. This is a short month.
I thought it was a lot of them. When we come back, we're going to go over those classes. And but before we go, tell people how they can reach your office.
You can reach us by writing to info@kbrlegal.com. You can go to our website, kbrlegal.com, and you can fill out a contact box that's on the main page. Or you can call us at 800-974-0680. That number's good for all four offices.
Okay, we're going to go to our break. It's a short break. We'll be right back with more of your questions and Attorney Robert K. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. We're here with attorney Robert K. of the K. Bender Rembaum law firm here, representing throughout the state of Florida. We just got a message from a longtime listener wanting to know, wants to know if an HOA board is allowed to tell a person how much they have to sell their home for.
In general terms, it's likely no, but that depends on the provisions of the governing documents. It's conceivable that the declaration can be amended or may originally have provided that allows for some involvement of the board in the sale of units within the community, but honestly, I've never seen it. I think that's a bit of an overreach for the board. Legally possible, but unlikely.
Okay. Let's talk about the classes you've got coming up in August.
Okay, well, according to my information, our first one isn't until August 20th, which is still a ways off. It's a Zoom from noon to 2 p.m. on HOA financial literacy and transparency. Kirsten Hens from Tampa will be presenting. There's two CAM CEUs and two HOA board member CEUs toward their annual requirement. And on August 21st at 11 a.m. to 2 p.m., these are all Zoom, by the way, HOA board member certification will be presented by Danielle Brennan from our Palm Beach Gardens office and co-hosted by GRS Community Management. On August 22nd at 11 a.m. to noon, there's another Zoom on guest restrictions and screening tenants and new owners. Kirsten Hens from Tampa will be presenting this as well. There's one CAM CEU and one HOA board member CEU. It's co-hosted by Artemis Lifestyles. On August 27th, we have a live event at the Tamarack Community Center down here in South Florida from 5 to 6:30 p.m. We have an Ask the Attorneys open forum that was an old favorite of yours. Andrew Black from our Pompano office will be presenting. Attendees will basically run that presentation by whatever questions they bring to the table. There'll also be light refreshments served. So that's at 5 p.m. on August 27th. On August 29th at 10 a.m. to 2 p.m., it's our big Zoom, the Condo board member certification course, which is tag teamed by Kirsten Hens from Tampa and Alan Schwartzfeld from our Orlando office. So that's all we have for August. But we haven't asked the attorney in there, and I know you like that.
Yep, I love it's. I got to tell you, I went to several of those, and it was amazing. I was watching a guy sitting right next to me, and he was looking like he was kind of bored when he came in, and he told the guy, "I got a question." This guy stayed for the entire hour and a half and ended up with like 7 questions. It was
Well,
amazing. Someone who came with 1 question, but people start asking questions, and then you get more questions.
well, COVID and Zoom seem to have caused that to be far less. But you remember pre-COVID days, we would do 5 or 6 of those a year. And
Oh,
if you're in
yeah.
the area, certainly feel free to come out, make a note.
They were amazing. Okay, let's get back to all the questions. Let's go with Richard in West Palm Beach. First, thank you so much for your show. Our board members always listen. Many residents are installing spotlights now, audio, video cameras on their garages. Does this require a vote of the community?
Did this questioner indicate condo HOA?
It doesn't say, I'm sorry.
Okay. Well, for an HOA, that's going to be a document-driven issue, and it's hard to predict whether the documents have such a requirement. Typically, they do not. In the condominiums, there's usually restrictions on owners being able to do anything outside of their units. The question would be whether it would be considered a material alteration that requires a unit owner vote. If the association is not doing it, but the owners are doing it themselves, that could be outside the scope of the material alteration aspect of the statute, but it's still one that would require some authority in the documents to allow for that to happen. So in both cases, I'm going to say that that's going to be an issue that needs review of the documents, and they should check with their association attorney on a more detailed answer on that.
You know, Robert, with hurricane season right around the corner, actually, it's
Oh, we're
here
in the
now.
middle of it.
Yeah, we've been getting a lot of questions, and mainly people want to know if they tell their next door neighbor to trim their trees because of a hurricane or tornado, and they don't do it. And a hurricane comes around and a tree falls on their roof. Who is responsible for fixing that roof?
Well, it's a tricky question in that setting because the general rule in Florida is that the homeowner that is damaged is usually responsible for their own losses from flying debris that comes. And the caveat on that is that the neighbor would have had to have been negligent in the way they handled the tree trimming and tree maintenance that was a direct cause of the tree coming loose and falling onto their neighbor's property. And that's a pretty high bar to clear to prove that negligence. Now, just because the one neighbor believes there's an issue and suggests they trim their tree doesn't mean there actually was an issue. And it was just an act of nature that it was a hurricane, and lots of trees blow over in hurricanes that are otherwise perfectly healthy. So in all likelihood, it falls to the property owner who's damaged to handle the repairs. And the same thing, if a tree falls down in your backyard that from your neighbor doesn't land on your house, but your backyard's full of trees, that's your responsibility to clear out, not theirs, even though it was their tree. Once it crosses your property line, that makes it your responsibility. And that goes along the lines with overhanging branches. When owners are unhappy with their neighbors' overhanging branches, then they want them to trim them. Whatever's crossed your property line, you're allowed to trim, and as long as you don't do harm to the tree in the process.
Robert, I'm going to stick this in because I was just thinking about it. Um, you know, every time I've been to your office in Pompano, there's always two or three ladies at the front desk. And I'm bringing this up because customer service, I know, is so important to your firm. And
I
I get letters from people saying to us, the firm that was representing them, they would call them up and it would take weeks to get calls back. And I want people to know out there because this is an area that's so important to you as customer service.
Absolutely. When we get calls from our clients, they're not calling because they just want to chat or they're
Right.
checking in to see how we're doing. They're calling because they have a what they believe to be a problem that needs a fairly immediate resolution. Oftentimes, we're having a board meeting tomorrow morning, and we need to know what the situation is with whatever we're calling about, and we got to get that to them that same day, and we do that. That's what we recognize. We're in the service industry that owners need to be served, board members anyway.
Well, I know with you being the senior partner, I know how important that is to you and how important customer service is. And I hear about the complaints out there. So
Well,
just
it's been the philosophy of the firm since day one, and that's how we grew.
Edwin in Boca Raton, HOA. Is it true a board can only enforce the newly amended covenants on the homeowners that voted for it or purchased their house after the covenant was enacted?
This refers to provisions in the law that started in condominiums and then was adopted for HOAs, but it's not all covenant amendments that they're talking about. It's only rental restrictions. Um, so the legislation was adopted in condominiums sometime around 2006, and it provided that any amendments that affect rental rights, in a nutshell, limiting, or if you're making more expansive, that's different. Like if if your documents say you can only lease for 6 months and you change it to 12 months, that provision's not going to apply. But if you're changing it from 12 months to 6 months, restricting the rental ability, then it's only going to apply to those who vote in favor of it or those who purchase the unit after the amendment's been adopted. That was added to the HOA statutes a couple of years ago. I think it was in 24. And the issue for HOAs is a little more complicated. It probably is the same issue in condominiums, but it was never really raised that way. The concept, what's called Kaufman language, is a provision in the law that the Constitution says that the state cannot adopt a law that will impair an existing contract. That's both the state constitution and the U.S. Constitution. The Declaration of Covenants is a contract, and it has vested rights of the owners and the association, and certain changes that they make in the law, if they don't have certain language in the declaration that incorporates future changes in the law, under a strict legal interpretation, the new changes would not apply. So this is one of those things. The ability to lease and to amend your documents relative to leasing is a substantive vested right. That's the legal terminology. It's substantive as opposed to procedural. Substantive changes to the statute cannot be retroactive. They can't be applied to existing circumstances, only on future circumstances. So your documents have to contain language that incorporates the statute, the HOA statute, Chapter 720 of Florida statutes, the magic languages as amended from time to time. Most HOA documents do not have that. So if the legislation came after your declaration, then the legal position is that it doesn't apply. So the issue on the rental change in amendments is one of those. Another one is on the commercial vehicle freedom that the statute put in, limiting abilities of associations to enforce on certain types of vehicles is another substantive change that would require what's called the Kaufman language in your declaration for it to be enforceable in your community. And that has created a lot of issues around the state.
Here's I've never heard of this before. As long as we've been doing the show, Karen in Fort Lauderdale, she says, is there any legal recourse that can be taken against a board of directors if their decision to cancel, this is why I've never heard this before, a no change order contract for a 50-year restoration project ultimately turns out to cost the association more?
Well, I think we need more facts to give a complete answer on that one. But in general terms, for a board member to be
What is the no
held,
change order?
it has to do with the contract that's being performed by the contractor. So I'd need to know more specifically what it's referencing. But in more general terms, in order to hold a board member personally liable for anything, you'd have to be able to prove that they acted in willful disregard of what they knew to be wrong, or were grossly negligent, which is along the same lines as that, or did intentional misconduct, or received an improper personal gain from the decision that they made of a financial nature. So if a board member makes a mistake out of negligence, they whatever this fact situation is on a no change order, the board member decides without getting sufficient guidance, and it turns out to be wrong, that's not going to be a personal obligation of that board member. That could be the association having some culpability for it, but it's unlikely that an owner can sue themselves in that regard based on their insurance. So it's a complicated problem. I'd like to give more of an answer, but I need more information to do that. I think you froze.
Oh,
You were frozen for a minute, but I think you're back.
okay. I know a law was passed about restricting work vehicles with writing on it. Is that for condos as well?
Well, that's what we were just talking about a couple minutes ago. No, that was an HOA change only. There is no vehicle issue in the Condominium Act relative to protecting vehicles from enforcement.
This is a condo, Christian, Miami. Are we allowed to have a line item on our budget for social events? Must we have a community vote, or can the board just vote on it?
That's going to depend on what your declaration of condominium identifies as proper expenses of the association. In order to have social events in your budget, there there has to be some authorization to spend common funds on social functions. Sometimes it's contained in the powers of the association for health, safety, welfare, and recreation. There does need to be some express authority in order to spend money that way.
Barbara in Delray Beach once, she's a condo. Don't committee meetings have to be posted and owners are allowed to sit in via Zoom?
For condominiums, most committee meetings are of that nature. When a quorum of the committee meets to conduct the business of the committee, they are treated the same way as a board meeting. There has to be the proper notice out there, and there has to be the opportunity for owners to attend and participate. Whether or not it's Zoom depends on whether or not they're doing their meetings that way. And Zoom is not mandatory, that's an option. The committee can do it just in person if it chooses to do that.
Stephen in Fort Lauderdale, this is a condo. Can a 718 condo association change their budget mid-year without notice to owners and a board vote?
The answer to that is no. The board can change their budget mid-year, but they cannot do it without the same notice they are required to give when they adopt the budget in the first place. And they can't do it without a board vote because it's a board adopted budget. That's express power of the board is to adopt a budget, and the board would have to then change the budget. So hopefully that's not happening for Steve.
Yeah. Christian Boynton, is it legal to access a unit owner before a contract repair is approved and signed?
Access what?
I guess access a unit, owner's unit.
Wait, read that again because it sounds like
is it legal to access a unit owner before a contract repair is approved and signed?
I'm not following the question. I guess we need to go on to the next one.
Yeah. Sophie in Lake Clark Shores. What is my name? Oh, that's another tree one. Kathy in Boca Raton, condo. What if a board calls for a workshop to avoid committee meetings? They still have to give us notice.
Well, it depends on what we're talking about as a workshop and what they're doing. The law requires that when the board, a quorum of the board meets to conduct association business, it's required to post notice and allow owners to attend and participate. The phrase conducting association business is not defined by the statute, and it's not defined by any court decision, but has been considered through the years to mean taking formal action. So being presented with issue a resolution for consideration and a vote of the board on the issue and a final decision made. That would fall within the definition of a board meeting that is required to be posted and noticed. Fact-finding, gathering, and informal discussions on topics are things that don't qualify as a board meeting that requires the posting and owner attendance and participation. And the same would be true if the workshop consists of less than a quorum of the board. So it really depends on what they're doing as to whether or not they're required to open it up and allow owners to be there and participate. In many instances, workshops do include a majority of the board or all the board, and they're talking about things and deciding things, even though they're calling it a workshop. So they do tend to post notice and allow owners to attend, but it's not a good idea to try and circumvent the statutory requirements, because that tends to get them in trouble.
Nancy in Boca Raton wants to know if a quorum of directors is meeting with the contractor and engineer to discuss work progress. Is it required that this meeting be posted and owner participation be allowed?
See, that's an instance that they're not conducting association business, and in all likelihood, they're not acting in their capacity as the board, but more likely in their capacity as the officers of the association, in dealing with the day-to-day aspects of the operation. Decisions aren't being made per se as they would in a board meeting. It's more of a day-to-day function issue. Now, if decisions are made outside the scope of a meeting because of circumstances that come up during the handling of the project, those should be addressed at the next opportunity at a properly posted meeting, as an agenda item and ratified.
Kurt in Boca Raton, I guess he is a condo president. He says, we have 120 residents. Should they be invited to meet and tour with any contractors working on our building?
Well, I think that's along the same lines of an open meeting. If board members are walking the property with contractors to either show them so they can prepare specifications and quotes for work, that's not a meeting of the board that requires posting and owner participation. So the answer to that is in all likelihood no.
Okay. You know, it's amazing. When we first started doing the show, we used to get so many letters about support animals, and
Oh,
we
yes.
rarely get those anymore. But
Well,
here's
they've
one.
been around for a long time, so most of the questions are answered.
So here's Kyle in Coral Springs. He says, we have a no pet policy in our docks. We accept service animals and emotional support animals. Some people have not filed any paperwork. We know we can find them, but what recourse is there?
Well, when you're dealing with emotional support animals in a residential setting, you have to be very careful in what you do, because it's very easy for somebody to claim discrimination, and the governmental agencies that review these things tend to view these more favorably from the complainer's perspective than the association. So you want to make sure that you're protecting yourselves and the association by following a very strict procedure. So the first thing that you need from a requesting owner is information to support their claim of the need for this emotional support animal. The law provides for a qualified medical professional to provide some form of authorization in written form that identifies the need without necessarily getting into what the physical issue is or emotional issue is with the owner, and what the specific animal does to alleviate that problem. And it has to be of a major life function. And you're entitled to request and receive that information before they're able to properly bring the animal into the community. We have a package that we create for our clients that contain application forms and information to share with the requesting owners and have them submitted back to the board for them to evaluate and approve. It's dangerous to simply say no to a requester without getting sufficient information. So that's going to be your primary pursuit, and you should involve your association attorney as early as possible. Do get a package that you can use for requests, and if there's anyone who's not following it, do be sure to get legal advice as to the best method of addressing that on a case-by-case basis.
Well, Robert, that's going to actually do it for us today. I just want to tell people also, thank you. A lot of people go back to listen to your shows. I see how the numbers go up a couple days after your show, and we appreciate our listeners, our viewers. And Robert, congratulations. You are our top show. It's a pretty big deal with all the people that
I'm
we serve.
honored at the distinction. I very much appreciate it.
We love you. Tell people how they can reach your office again.
You can call us at 800-974-0680. You can write to us at info@kbrlegal.com. You can go to our website, kbrlegal.com, and fill out a contact information box on the main page, and you will hear from us relatively quickly.
Robert's with us every month, first Thursday of the month. Robert, have a wonderful weekend.
Happy August, everybody.
Take care. That's attorney Robert Kay. He's a senior partner at Kay Bender Rimbaum. They're a community association law firm. That's going to do it for us today. Thank you, our great producer, Juan. And we will see you all next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.